Thank you. Mr. Armstrong, thank you.
Now going to work out which of, if any of these microphones work. Sounds like that one is. Thank you, Chair. I hope, does that sound like it's working to people?
It does to me. Yes. Can you hear okay?
Thank you.
Thank you.
Chair, my purpose this afternoon is to try to persuade you to be clear and definitive in your findings and to be bold in your recommendations. I do that because this inquiry is unique. It's not been done in this area before. The Home Office didn't want it, and they probably won't do it again. There have, of course, been investigations. There have been years of them. Yarlswood, Oakington, Shaw. I know that you know about all of those. There's also been years of litigation. There have been inquests. We've heard about Jimmy Mbenga under Prince Fosu, but there has been nothing like this. There has certainly not been the volume and range and intensity of the oral evidence that you have had. Litigation in this area is almost always judicial review or tribunal, and it almost never has much in the way of oral evidence. Inquests have a bit more, but they are necessarily limited in their scope, and they certainly don't have the assistance that you've had from the solicitor and counsels to the inquiry teams who have worked as hard as they have worked for as long as they have worked. So you are in this unique position. It's also, of course, the fact that none of that previous work prevented what we have seen in 2017 in Brook House. And it also appears that even when Panorama came out in September 2017, as happened previously with Yarlswood and Oakington, the secret recording itself wasn't enough to stop things. Serious problems continued. And you've heard evidence post the relevant period about what has happened when pressures have been put back on the system, including things like Dublin removals or small boats. And you've heard evidence even from Mr. Hewer last week about constant watches. There were two constant watches in the centre, and still it appears no 35-2 reports. So those problems remain. And all of that is, of course, with the spotlight of this inquiry on it. A key question of concern, certainly for those I represent, is what happens when that spotlight is taken away again, and how much and to what extent do things slide, because certainly in this area things always slide. Mr. Riley gave evidence yesterday. He spoke of change, but he too has been forced to speak of change. He was abandoning statements yesterday under questioning from Mr. Altman that he made as recently as the beginning of this inquiry in his witness statement, when more was being put to him. So we have, certainly from this side of the room, a degree of scepticism because we have been here so many times before. And as when that inertia stays, when that inertia entrenches, what happens is the number of victims mount because they remain in detention, and the victims that we already have wait for change or wait for a solution. So I'm afraid I'm here to say only you can do something about it. Only you can try to achieve sustained and reliable change so that this does not happen again. I also say that related to that, only you have the material because you have had the breadth and the depth of the evidence. And that starts with Callum Tully's footage, and then it moves into the sheer grinding awfulness of the granular detail that you have heard and have sat through. So the inadequate systems, the inadequate management, the inadequate staff, the parade of broken men. Remember, Mr. Lee talked about his client D643, the former army officer struggling with PTSD, and you may remember how he was on the stand struggling to give his evidence. The parade of unreconstructed men, the DCOs, unled and unguided in their attitudes. One or two people tried to stand up to it, but they got nowhere. So you've heard from Owen Sirod, you've heard of, and we've seen evidence from David Waldock, and of course there is also in all of this the women, the senior women, in fact, Stacey Dean, Michelle Brown, in my submission, broken too in their way, not here, including for reasons that Michelle Brown, you understand the reasons for that, and we've seen their histories of being stressed, having periods of time off work, and telling you how and when they raised matters, and you can see how far those got. You've seen their emails, you've seen the response or the lack of it, including when raised directly by senior people directly with Jerry Petherick in January 2017 in the Stacey Dean example. And one has to remember, if it is like that for them, if those people at their level can't get change or movement, what must it like being, or if they are reacting or experiencing that from Brook House, what on earth must it be like for the detained people themselves? You've heard a lot about their unique and vulnerable characteristics, and it is, again, we say, only you who can do something about it. Because if not you, then who? And if not now, then when? And I do just want to note the chronology, because it's not just now nearly 20 years since Yarl's Wood and 17 since Oakington. It is 6 years since Callum Tully was concerned about what he was seeing to contact the BBC in the wake of Medway. It's 4.5 years since Panorama came out. It cannot be said that the Home Office has not had the time to do something about this. And we have to ask, why haven't they acted? And we may see some answers to that in a moment. So we say that there is just one shot at this, and we certainly have to assume that there is only really going to be one shot at this, and I'm afraid it's you. Not fiddling with it, we say fundamentally altering it. Now, what do we say that you've seen, and you have sat through all of this, and I'm not going to go through all of the evidence. I don't have the time to give the evidence. You have sat through every witness. I think it may be just you and Zainab, in fact, and I think one other who's seen every single witness who in the room. So you know what they have said, and you have that. From our point of view, the key point that I would emphasise, and we presaged this in our opening, is the toxicity, the unique toxicity of immigration detention. Now, toxicity is a word that has been used a lot. Counsel to the inquiry has referred to the contagion of toxicity. I do want to say something about the language that we have heard. I'm not going to go back through it. I'm not going to repeat it. I am just going to say, keep in mind, of course, its extent and its intensity, and it has been shocking even for those who look at these things. Professor Bosworth told you last week, on 29th of March, she said, it's obviously completely corrosive. And it was, the widespread nature of those sorts of comments that are picked up on the undercover footage is genuinely shocking. And it clearly was not being addressed by management. It was widespread and, I think played quite a large part in the physical manifestation. And remember, when you're looking at the language, none of that would be acceptable, even in the high security prison estate, where you're dealing with extremely dangerous men. And this is not the high security prison estate. This is not even a prison. There are people that we have been looking at in this inquiry who've never been anywhere like this before. Gentlemen, guileless men, but even those who have been in a prison environment before, a wide variety of people, they too, often scared, often mentally unwell. They may have committed offences, but those offences may just be documents offences. They may also well be people who, and I'll come back to this, people who will in fact end up staying in the UK. All of them are experiencing all of this pretty much all of the time, with nothing being done about it, the use of the language not being reported, not being corrected, and not being stopped. And that is corrosive, as Professor Bosworth says, and it is dehumanising. And dehumanising is another word that has been used a lot in this inquiry. It has been the premise for much of the questions from your counsel. No one seriously disagrees about the characterisation of that. But it's worth emphasising the use of the word dehumanising, because we are fundamentally in an inquiry about Article 3 ill treatment, and Article 3 ill treatment is about treatment that is inhumane. And if you have language that is dehumanising, you will get to a position where it renders something inhumane. And we can look at authorities in due course about the importance of language. But where you have language that robs people of their fundamental humanity, and that dehumanising is the word that they are all using, then that does take us a long way, we say, to establishing that the treatment was inhumane. And I make another point here, which is a point that Ms Harrison's already made this morning, but both in phase one, when we heard from detained people directly, but also in phase two when we had the read-in evidence from detained people, men spoke of their experience of being, I felt like an animal, I was being treated like I was an animal. And it may very well be that those men spoke in those terms without realising the legal significance of the language that they were using, but it does have a legal significance because it is dehumanising. That's what they're describing, being treated like an animal. And so that is also very highly relevant in Article 3 terms. The second point I want to emphasise, moving on from language, is the extent to which we say this obviously goes, and we just want to knock this on the head, much wider than that which Panorama showed. There's been this discussion, and it's perhaps not a very helpful discussion, about whether it's bad apples or a bad barrel, and there was that exchange between Mr. Altman and Professor Bosworth last week about it, and we could debate about how many apples it takes to make a barrel. It isn't everyone in Brook House, but it is wider than Panorama, and it's certainly wider than those people who were dismissed as a result of Panorama. And you can see that because we have to add in a number of other groups, and that includes the people that you see on the unbroadcast footage, the people that you see on the body-worn camera footage. All of that is the footage, incidentally, that Mr. Brockington didn't bother to watch before he gave his evidence about it being a supposed minority, despite his organisation being responsible for producing much of that footage and producing it late. You have to add in all of that. You have to add in all of the people who didn't report the ill treatment and who were complicit in that sense. And then you have to add in a growing list of others who also seem, on the evidence, and we say, to be guilty of very serious behaviour. And you have within that list, and just to name a few of them, Luke Instone Brewer must be pretty close to the top of that list in my submission. You have seen an enormous quantity of evidence that he was supplying spice to detained people, and that he was making a lot of money supplying spice to detained people, and you have seen that evidence be multi-sourced. You've seen the intelligence that staff had and that Stacey Dean and Michelle Brown were talking about, and you've seen all of that material. Mr. Livingston took him through it, but you've also seen that chime with a completely different source of evidence, which is my client, D687. And he has talked about the detail of that and how he was supplying it and the way that it was done and the mechanics of how it was done and how it was £50 and 2 pence in order to identify that level of detail. And when that information, when that kind of evidence knits together, it shows you, my submission, that it is true. And what that tells you is that Mr. Instone Brewer was doing this or behaving in these ways in 2014-15 and raising concerns with staff then. It was raised again specifically with Mr. Petherick in January 2017, but he was left in place at Brook House until he left himself in July 2017. And you may remember, Chair, when he was being challenged about this, the slightly cocky way, we say, in which he gave his evidence, laughing as he started his evidence. My submission is we can see very clearly who he was and what he was, and draw the conclusions accordingly. We also have on this list his friend, Mr. Fagbo. He was also friends, who were also friends, both he and Mr. Fagbo were friends with Jules Williams, and I'm emphasising these people because both of those two came into contact, and we see it in his early witness statements. Again, my client D687, these were the people he was bumping into. Jules Williams was also friends with him, and you have these insights as the evidence emerges. You have these insights that come out of the detail, like Jules Williams and the complaint that was made about him, and he was asked about it in his evidence, mucking about with a banana apparently aimed at a gay female member of staff. When you look at people who are behaving like that, and he is a member of the SMT, and you look at what that is showing the people below him, and then you just imagine for a moment the dexterity which you think he brings or might bring to the pain and suffering or concerns of detained persons, you get a real insight into how dehumanising and difficult this environment was. It is awful stuff. And on it goes. We see Gayatri Mehra, Graham Pennell, Darren Tomsett, all of these names coming up in lots of different aspects of the evidence, all names with extensive poor behaviour and inadequacies recorded against them. And again, multi-sourced. We see Gayatri Mehra turning up in the David Waldock complaint. At the same time, she's turning up in the GDWG materials, where people are talking about how she was trying to stamp on things that she thought were second visits. There's no possibility of collusion between GDWG and David Waldock. You see similar things with Mr. Pennell. Mr. Lee has talked about that again this morning, and the extreme racism that he exhibited. And you see that that is being produced by D643, but it was also in Callum Tully's materials. Again, multi-source material that all knits together to show powerfully, we say, that the allegations are true. Mr. Tomset, top of the leaderboard as the most complained about officer at Brook House, which is something, given how many others were competing for that, and how reluctant people were to complain in the first place. Promoted to DCM by Steve Skitt. All of that material pointing in the same direction, all of them taking part all of the time with this casual language. And I just talk about that again. Where do you go when you've used the F word? Then they go to the C word, then they go to the N word. You think, where else can they go after this? And then you get Sean Sayers comes out with a new phrase that seems to have taken hold in this inquiry. And you see again just how toxic and degrading it has become. But now what you do have, we say, is a significant percentage of the staff list. And you have a significant percentage of that list, some of the behaviour that you're that is described here, some of them are still working at Brook House. So a number of staff implicated in serious wrongdoing, it's already been said this morning, Chris Donnelly, Steve Loughton, Steve Dick, Steve Skitt, all implicated to greater or lesser degrees, still working. And that's a real concern about achieving proper change here. But the point about how wide this is and how cultural, how culturally broad or otherwise it is, you can also take from Callum himself. He saw all of this in 2015 and 16, which is why he approached the BBC in January 2016. He then waited for more than a year. He took notes, and they checked whether it was still all happening. They went through the editorial process, realised it was still happening, and so started filming. And he told you on the 30th of November, he said, I know why the inquiry is interested in the relevant period. It's because of my filming. But then he said this, but to me, it's the years and months before that that were just as relevant, if not more relevant, because at least I was able to capture some of the abuse between April and August. You know, to be honest, it's not the things I saw while secretly filming undercover which troubled me most, because at least I filmed it so the world can see it. But it's the stuff that I witnessed before I started wearing secret cameras. I know you're going to ask me about one incident in particular. You know that's the hardest stuff, because those officers have gotten away with it. And it seems G4S and the Home Office are only being held accountable for the months of April to August. And I hope that's not going to be the case. The point just comes down to, he didn't just get lucky with what he filmed between April and August. That was representative of the period that he had seen for at least the preceding year. And I said this in my opening, and I'll say it again. This is just not a snapshot. It is indeed a panorama. Mary Bosworth also told you on the 29th of March, we can argue about the numbers, but there are clearly systemic issues here. We say they are deep ones and that they are long-standing ones. Now, just while I talk about Callum Tully's evidence, I want to make one other point. The inquiry has heard a lot from him. He has given evidence over 4 days, so in fact he's been pressed harder and for longer than any other witness. You've also had the benefit of his notes, his full footage, including during unguarded moments. We all remember the time in the toilet. And my submission is that he has answered the questions that were asked of him clearly, openly and precisely. I imagine that, like the BBC, we will, and I imagine the BBC will also do the same, invite you to accept him as being a witness of truth, unlike a number of other people who gave evidence to you. But the inquiry has also seen these ongoing number of allegations, still mounted, sometimes even here in oral evidence, by the DCOs and the DCMs he filmed, who have persisted in this range of allegations that he doctored or dubbed footage. You may remember the exchange between Mr. Altman and Mr. Connolly about this, where Mr. Connolly was saying, is that a serious proposition, Mr. Connolly? When we're all done here and we all moved on and the chair retires to write her report, is this how you want to be remembered? And it was only after that that Mr. Connolly finally abandoned this implausible point and went, no, actually, no, I don't. That's what it takes. That's the inertia we are seeing in order to get them to move off these attempts to minimise and say it wasn't me and not to acknowledge and not to reflect. But we've still had the senior people, we've still had people like Mr. Needham persisting in claiming that Callum should have reported, that he could have relied on the systems, and then saying that people were harmed because Mr. Tully did not do that. And, Chair, I just want to note that. Others represent Callum, but I do want to note that on behalf of those I represent, all of that is obvious nonsense. Those kind of statements are entirely reprehensible, and we say that two things should flow from it. First, we say that you should reject it expressly. We say that Mr. Tully's actions in bringing all of this to light have been entirely exemplary, and we should all be grateful for them. It can't sensibly be suggested that he did anything other than the right thing. 20 years old, and he managed to stand up in the face of all of this when other people who were much older, much more experienced, and whose job it was to do this stuff, stayed silent. And we say the inquiry should record that and record its gratitude. He stood up when the system of which he had happened to join crushed so many others. But secondly, we should just reflect for a moment in relation to those who persist in these baseless allegations and nonsensical allegations against him. Record that too, and bear in mind what that means for the chances of sustained or reliable change. And this is just propping up the submission I make to you about being bold, because that's what we're facing down, this persistence of holding the line. Because that doesn't look like people who are seriously interested in changing, people who are seriously interested in examining their own actions or inactions or taking responsibility for them. Instead, they are determined to minimise, and we say that people who maintain those fictions as an attempt to cover their own responsibility should be called out on it. They're also, Chair, the longer that goes on, the longer they hold that position, all they are doing is holding up the real change that the system requires, and as they do that, the victims mount and the victims wait. But returning to what we saw with the DCOs, can I also just make this point very clear? It is entirely hopeless to suggest that it stops with them, or even with G4S more generally. That is, of course, who Verita were looking at. They were looking at G4S primarily. But it obviously goes up to the Home Office too, because they are ultimately the detainer, they are the contracting department with the enforcement powers, and we have to look at where all of this comes from. If we're looking at leadership and void of leadership and so on, what leadership or tone are they showing and setting? And we say that's very obvious. You see it everywhere you look. Start at the bottom end and look at the likes of Vanessa Smith in that February 2018 Hibiscus training session, laughing along, using some of the same language, certainly not reporting the language as Hibiscus did. And you will remember, Chair, that was 13 separate upheld allegations of misbehaviour in relation to that incident, and the language was serious. Hibiscus reported, nobody else does, and that was 5 months after Panorama, where they were supposedly looking at this stuff seriously, because Panorama had just come out, and it was 2 years after Medway when they were supposed to be looking at these things very seriously. When she gave evidence to you, Vanessa Smith couldn't say why she didn't report it, but that, as I think he accepted yesterday, did undermine what Mr. Riley told us in his witness statement about having the confidence that had they seen it, officers would have reported. No, they didn't, because they did see it 5 months after Panorama and still didn't report it. And that was put to him. Mr. Riley told you that he got a daily update from the inquiry, but didn't appear to get an update on that issue about one of his own officers. He hadn't read the material, he hadn't read the investigation report, and he said this. Mr. Altman put to him, presumably, Mr. Riley, none of that is anything that you would expect of a Home Office officer. No, it isn't. Do you think that undermines your confidence in Home Office attitudes or a willingness to report, or do you think it's just a one-off? I would hope that it's just a one-off. Well, on what basis do you think it's a one-off, is what follows from that. Because, and it means this, when Mr. Riley thought about what needed to be done and what needed to change, he did it not knowing that Vanessa Smith or immigration officers were behaving in this way. And that can't be a promising basis for sustained or meaningful change or reform. But moving on from her, you also look at Mr. Gasson, start moving up the scale and look at Mr. Gasson, and Mr. Gasson is, we are told, doesn't often come out of his room, doesn't like to mix with detained people, but when he does turn up in the evidence, we can see a number of things. Nathan Ward talked of his cold functionality, and you may think that matter for you, of course, but you may think that you saw some of that in the way that he gave evidence. You have more direct evidence of that in the evidence of James Wilson of GDWG. You remember the meeting in August 2017. Now, I want to just touch on that briefly. What on earth was the problem with GDWG? You may think gentle people trying politely and appropriately to help people who we can see obviously needed that help. They were filling in the gaps in a system which obviously had many, many gaps. Yes, they're a campaigning organisation for many years for the end of immigration detention, but they do have force in that point. There are absolutely grounds for that campaign. What was the response? What was the response of the Home Office to them? And you have Mr. Wilson's oral evidence where he said this. That was a dynamic that I felt was increasingly there. I was vividly aware of that in that meeting. The dynamic. I remember the meeting very vividly. I remember it was Steve Skitt and Paul Gasson who were in the meeting. They were nearest the door. I was on my own. They were very, very agitated. Very, as I put it, I felt that they were toying with me. They were threatening with something, and very immediate threat to our access. I remember it being, in my recollection, it was a dark and rainy day. I remember walking out of the centre feeling shaken by the meeting, and I'd had meetings before when they'd been difficult, but I was really shaken by that meeting. And that evidence is supported by the contemporaneous email that he wrote and that you've seen, where he talks about, I've just had a gruelling meeting, drop-ins are on a knife edge, it sounds draconian, but this is serious. And you may have picked up that he didn't give as much detail the first time he gave evidence on this, which was in his witness statement for the judicial review which produced this inquiry. But the reason why he was saying less at that stage is also something that he explained in that witness statement, which he was scared of losing drop-ins at that stage, back in 2018 when those proceedings began. He was still very worried about what might happen if he challenged G4S or the Home Office. Both Mr. Gasson and Mr. Skitt were challenged about this and were asked about what they did, and both of them simply gave the manifestation of bullies who had just slightly been caught out and without sullenly staring at their feet in the head's office, giving grudging apologies, saying, well, if we were hostile, we didn't mean to be. By way of also further emphasis on this, remember, it's been referred to a couple of times already, but that Naomi Blackwell statement, she gave evidence, and you've got the witness statement in the materials, about, in a very sober, very restricted way, talking about an incapacitated detained person who was obviously very vulnerable and who turned out was not only unlawfully detained, but was being detained in breach of Article 3. Now, the knowledge of that witness statement, the way G4S and others came to know of that witness statement, must have come from the Home Office because it was the Home Office that was the party to the litigation. When that comes to light, what do? They don't respond saying, oh, this is very serious, we've got a vulnerable individual in detention who maybe shouldn't be in detention, how have we missed this? They attack GDWG, was their response. How dare they write the statement? Remember then how GDWG come to be examined and described in all of those meetings. And you will remember the phrase, the problem is one of trust. The problem is one of trust. Immediately characterising as this as an us and them situation. GDWG are a them, not an us. They're on the wrong side of that line. And all of that is, of course, stifling the production of evidence and seeking to stifle the production of evidence that was very desperately needed. But in an Article 3 context, because if you're stifling the production of evidence in an Article 3 context, you're breaching Article 3. Now, as well as, it may be noted, in August 2017, driving or helping drive the IMB to a degree of hostility and distrust towards GDWG. That is pretty serious and pretty telling stuff. And it was the Home Office at least as much as it was G4S. And you will remember the evidence of Mr. Horton, who thought that who told you that the steer he had with regard to GDWG was unfortunate and was a shame, but it came from the Home Office and from Ben Saunders. All of that material, Chair, points in the same direction. It certainly doesn't point to a compassionate approach. In fact, I don't think we can see at the relevant period any evidence of any Home Office official behaving in a compassionate way towards a detained person. It also chimes with other material. It chimes with Lee Hanford in his Verita interviews and in his oral evidence, talking about G4S having been criticised for being too empathetic. Ben Saunders was asked about that evidence, and he agreed that he also had that take. Ben Saunders was, of course, trying to please the Home Office. He was said to be good at it, but he did that by showing little or no empathy. And he told us, we heard that he stayed in his room, as well as Mr. Gasson staying in his room, not being visible. And that's important because it is, of course, much easier to mistrust, and it is much easier to mistreat and much easier to dehumanise if you do it from a distance. If you separate yourself out, you will find it much easier to mistreat. Now, so that's where we say, that's when you look at all of that evidence, that's what you see about the approach of the Home Office. But is that really very surprising that you are finding those sorts of uncompassionate attitudes from the Home Office? When you look at things like the overall political rhetoric in this area, the overall agenda of the Home Office, and you see that in all sorts of places too. So you look at the contract, and you see the absence of relevant provisions. So there's nothing in there on welfare. There's nothing specific on welfare. There's nothing on checking use of force in Schedule G. You look at the way Schedule G works or doesn't work. You look at the focus that everybody describes on immigration throughput. We've looked a lot at things like the KPIs and the complete absence of any KPI in suicide and self-harm despite 60 incidents in the relevant period. We can't see how that system could sensibly have worked because in order to have a KPI, it requires all these steps in the chain for Barry Timms to find out in order to report it and then to get sufficient information to characterise it as a procedural breach, and then somebody to check whether that judgment is correct. Mr. Gasson is asked about that. He can't remember doing it, doesn't know how it worked. Mr. Castle didn't know how it worked and couldn't remember the system either. And the reason why they can't is because there wasn't one, because it wasn't happening. And the only inference you can draw from that is because nobody really cared about whether G4S was failing in its monitoring of suicide and self-harm arrangements. I would just ask briefly about that. How is that happening now? Because the KPIs in the contract now, how does that now work? How have they improved those or filled in those gaps in the system? Again, we've had 2 people on constant obs. Have they self-harmed? Has that become a KPI? Has it become a Rule 35.2 report? Dr. Uzerali tells us he's never done one, etc. You've also got, in all of this, the use of force. Obviously a critical issue for this inquiry. You know that the use of force reports were done much later, sometimes by the same person who was involved in the use of force. Steve Webb did that. Just dealing with D687 himself, the use of force on him, or the key one, is the 13th of May. The use of force review form is done on the 31st of July, 2.5 months later. Tick box, not even picking up the fact that BWC body-worn camera footage wasn't used, even though the box was ticked for it. And you'll remember how important that is, because Mr. Collier told you how important it was. If you don't review it, if you don't pull people up on it, then they won't write their reports correctly, they won't write their reports accurately, they won't learn, and nothing will change. Chair, in my submission, the use of force in this case was a car crash. So much of it was badly done, but again, nobody seemed to pick it up. No scrutiny committee meetings. Nobody's picking up the fact that Steve Webb is both being involved and doing the review and doing them 2 months later. Then tie in, all of that shows no real interest in welfare. But of course you see it in all of these other places, like no 35.2 reports. 4 years. That is astonishing, and nobody picks it up. Article 3 findings in respect of this detention centre. Article 3 findings more generally not being handed back. Nobody can tell the system for feeding that back to the people involved. What on earth is going on? But moreover, what kind of message is that sending? What is that saying to the DCO on the wing, who has never done anything like this before, who is paid £25,000 flat rate a year with no chance of an increase, understaffed, in the noise, firefighting, and is unguided and unled? Is that saying to that DCO, spend more time, engage more, try to understand what is happening with this vulnerable individual? Of course it's not. And where will he look then for help and support? And he will look at the people above him and look at how they are behaving or expressing themselves. Chair, the Home Office, I've talked about political rhetoric, the Home Office wanted a hostile environment. They got one. This is what it looks like. They need to own this. The consequence of that is, it is degrading and it is inhumane, and that's what it flows from. It's also, of course, the Home Office that built a Category B prison on the fiction of a 72-hour detention period, so they didn't bother building much in the way of outside space, very few in the way of activities. Everything in that, too, says that we don't care. And Mr. Riley yesterday was asked about the culture of the Home Office, and he told you, we live in a society where the debate on migration and enforcement is polarised and entrenched, and that doesn't help either. It's a difficult operating environment. Who do we think drove that, Mr. Riley? Where do we think that came from? Who do we think is polarising the debate on migration and enforcement? So that's what I say about the Home Office. On the other side of this, of course, we have the detained people themselves. And I gave you in our opening the list of characteristics and vulnerabilities: mental ill health, English not as a first language. I know you have all of those points. Much harder to build relationships, which is the normal way in which you run establishments of this kind, is by building relationships. It's much harder to build relationships when you have those characteristics. I do want to just briefly summarise some of the characteristics for D687 himself. You've seen a bit of him around. He was at the early stages of the inquiry. Cheeky, likeable man. I hope you'll forgive me for saying so. He finds it quite hard to watch, turns up in court and finds himself on the video, which is part of the reason why he's not been here as much. And he has recurrent depressive disorder, PTSD. He's suspected of undiagnosed learning difficulties and bipolar disorder. Been in the UK nearly all of his life. He might well have had British citizenship, but for the fact that he was in care and social services didn't apply for him, so the rest of his family got citizenship and he didn't. And he was in care because he'd suffered childhood abuse. He's not had an easy time, hasn't D687. Schooled here, family here, being told regularly fuck off home, but feels that he is home. His suicide and self-harm, clearly there for years, clearly serious, well recorded. Remember the scarring, which only came out in this inquiry, because when his solicitors saw the unreleased footage that nobody had seen before, they saw him doing something and said, "What are you showing the officer there?" And then he showed them, and that's how the scarring came out for the first time. So he's always found it difficult to express himself about those things. And by May 2017, 2 years and 3 months in immigration detention in that patch, and a year and a half of which have been at Brook House. And that's, of course, very significant because he's had all of the stuff that we're looking at for that period of time. And he was significantly suffering as a result of that, which is not very surprising because all of the medical evidence that you've had, all of the independent doctors in particular, have told you how detention impacts. They've told you about the indeterminate nature of detention in particular and how that impacts, and D687 had done a lot of that. And throughout that time, he has been bumping into the likes of Luke Instone Brewer, who he has described in his early witness statements. We can imagine how that was, and we can imagine how those interactions were. And Vanessa Smith, who he tells he's writing a suicide note but doesn't open an ACDT, or Dr. Uzarali, who doesn't open an ACDT either and doesn't do a 35-2 report. And he had just at that point told his individual, for the first time, he'd opened up about his childhood abuse and the story of his life there. Where does it get him? What does that tell him? He opens up and nothing happens, so it tells him the system really doesn't care. And remember Dr. Hard here, because these interactions, he told you, these interactions being regularly dismissed has a negative impact on mental health. And D687, we say, is the paradigm of that. You may not need Dr. Hard's evidence to understand that. And just put it all together, imagine what 2 years, 3 months of that must be like. Being denied the identity that you feel and believe to be yours, not being taken to the funeral of his brother and his grandmother. Remember here the contemporaneous notes, Callum's video diary of his deteriorating. And where does it end up? In a disabled toilet with a ligature around his neck. He goes into the disabled toilet. He's too broken even to lock the door properly. "I've had enough, bruv. I want to go, bruv." That's what he tells you. That's what we hear on the video. And Brook House has reduced him to that. That has degraded him. That has dehumanised him. That has broken him. And where does it end up? It ends up with a use of force, which in domestic legal terms, Mr. Collier can't justify. And because it's not planned. There's no healthcare present despite the ACDT, despite the ligature. There's no BWC footage, despite it being a duty director who's in charge that day. There's 2 DCMs who are wearing BWC but don't turn it on. They are both individuals who abused D687 in the course of the use of force. One of them is responsible for the, we'll just wait for it, if you do put it on, we'll wait for a minute until you pass out and then we'll cut you down, said by DCM. Humanity chair at that point has left the building. And then Mr. Collier says if they should have engaged more, force may not have been required if they had. Then they use the trick with the cigarette lighter. They take him to the ground. He's got 4 or 5 men on top of him whilst he's still got a ligature around his neck. They cuff him. He's subdued and in cuffs, so he doesn't appear to be a threat to anybody. But at that point, he's got a pain-inducing inverted wrist hold applied. And he cries out in pain. And we also know that he turns out when he gets to hospital later in Dorset that night, when he's got to the Verne, he's got bruising to his ribs which has not been explained. So, Chair, in relation to him, we say, in relation to D687, he was degraded and in breach of Article 3 before he entered that toilet. But when you, he's a very good example of what Brook House can do to you, particularly over a sustained period of time. But if you add in a domestically unlawful use of force, an unjustifiable use of force, into that mix on top of that, then that is the breach. And that is where it all absolutely goes over threshold with that final, slightly chaotic, thoughtless act, unplanned, as it was by Duty Director Horton. Can I also just bear in mind what D687 has said about all of that, and the number of times he's told the story about what happened then, before the footage came out. And when the footage does come out, and we've been able to examine it with the detail that you've been able to examine it with, it does show that he was right in terms of what he was describing, and it shows also that the PSU was wrong about that. And I haven't got time to go through the difficulties of what the PSU does and the way that it does it. Not checking things unless we don't check things unless you can tell us what date it was and which individual it was. We won't do it. We won't weigh in. I will dismiss the allegations of racial abuse because I won't weigh, because it's not in front of me, what panorama is showing about racist abuse. But he's clearly right. D687 is clearly right about that, and we say the PSU was wrong because of the narrowness of the approach that they took. But that PSU dismissal degraded him, D687, yet further. So those are the findings that we invite you to reach, Chair. There is some law to deal with here about the correct approach. I am not going to go through that in any detail. We have CTI's note on it. We may have some points of difference, but I think they will be minor difference. What I say about that is essentially this. You'll need to reach findings about what happened. You'll need to reach findings that inform an Article 3 assessment. That will mean looking at what happened, but also why it happened. And when you come to look at why it happened, you will need to look at things like the motivation of the abuser, any justification for it, the language which surrounds it, whether that's intended to degrade, whether it's racist, because that sounds particularly heavily in an Article 3 assessment. And D687 had all of that. But then you will need to look at things like, even from an individual breach point of view, even the individual treatment point of view, things like official indifference or the failure to operate safeguards is also relevant to whether or not you get to an Article 3 threshold. So that will require you to examine the systems, the training and the resources, even on that individual assessment. One will have to look at both what happened and why it happened, and that will take you into systems issues. When you then come to look at whether there are systems breaches, again, I'm going to leave this to written submissions, but you are concerned here with whether there were inadequacies in the system which materially increased the risk of an Article 3 breach. Or to put it another way, would a system without these inadequacies have had a real prospect of producing a different outcome? Now, I'm slightly borrowing that phrase from the operational side of Article 3, but it must be the same. Now, what Counsel to the Inquiry is saying, that there will need to be something that ties a system breach to an individual breach, so there will need to be a system that produces a consequence, there'll need to be an impact. We say you won't need that, because you can be future looking and say, is there an inadequate system which might produce an outcome of that kind, and that would be an Article 3 breach, and therefore you should look at it. But it's very difficult. I'm not sure I need to get that far, because it's very difficult to look at all the systems that you have been examining through the course of this inquiry without finding somebody who that will have had an impact on it. That will have had an impact on. So whether it's 5-minute Rule 34 assessments, or whether it's Rule 35.1 and 35.2 reports, or the reliance on Part Cs, or the absence of use of force scrutiny, or the absence of staff, or staff culture making systems ineffective because they don't believe what's being said about suicide and self-harm ideation, all of those are capable of being Article 3 systems breaches, and all of those are impacting, we say, on the people that you're hearing from, including, to a large extent, D687. So we say there will need to be findings, and we invite you to do that in relation to all of those matters. Now, where then does that take you? I started this by saying I was going to invite you to be bold in your recommendations. What does that entail? Now, back to this point, we say that the problems here are too legion, and they are too manifest, and they are too long-standing and too entrenched to call for anything short of fundamental change. Otherwise, you're facing too much inertia. Look at how long these go back. 20 years to Yards Wood. Look at how the Home Office had to be dragged kicking and screaming to do it. It required an order. They said in the judicial review, there is nothing here to be found. We don't need to do this. We don't in particular need to have witness compellability in order to get Jan Pascal. You don't need the powers to hear from Jan Pascali or to hear from the others, or from Connolly or from Nathan Ring or any of those individuals. You did need to hear from all of those individuals. To understand how bad it was, you did need to hear from all of those individuals. And you needed to have that enforcement power available to you. So the Home Office was wrong about that, as it has continued to be wrong about many things. And I've already said, Phil Riley was still revising his remarks yesterday on Rules 35(1) and 2, and on Part C. He was also, yesterday, when he sought to reassure you that it was now a changed Home Office under him, he told you that he said, Chair, we have done an awful lot of work over the last 4 years, 3 years, 4 years in learning from the Wendy Williams report, which was a slightly astonishing piece of timing given that Wendy Williams had issued her Windrush progress report 5 days earlier, when she said that which contains 13 expressions of disappointment in the progress that has been made in relation to Windrush. Only 8 of her 30 recommendations have been acted on. Much more progress was required, and there was limited evidence that a compassionate approach had been embedded consistently. So none of that is giving a great deal of reassurance, you may feel. Mr. Brockington also sought to reassure you. Changes being made, it's only a minority, etc., etc. It's not immediately clear to me how he was seeking to persuade you or be persuasive in circumstances where he hadn't read the Mary Boltworth report, he hadn't read the transcripts, he hadn't listened to the key bits of evidence, and he sought to come along and tell you what he knew when you have heard all of that material at great length. Again, not a terribly promising start. But what those attitudes tell you is that these are not organisations that welcome change. These are organisations that tell you what they think you want to hear in order to make the issue go away. And they will need, again, I've said this already, to be dragged kicking and screaming into any serious alteration. They've also told you, a number of them have told you, Mr. Riley in particular has told you, and told you in some detail, that further change is waiting for the Nationality and Borders Bill. And you can be reassured that because big change is coming in relation to that, and they'll do something after that. But when you look, you don't have to look at that very closely to be pretty concerned too. Do we think that a Home Office that is currently proposing offshore processing of asylum seekers is seriously committed to migrant welfare? Do we think an Ascension Island Brook House is going to be better than this one? What do we think the scrutiny is likely to be there? What do we think an Ascension Island IMB is likely to be like? What do we think that degree of removal from the world will do for the situational psychology of that detention environment? So, we say one has to be fundamental in what one does. Now we work down the list of the other things, and I'll just do mine briefly. One can adjust the contract, as it is said, it has been done. But as I've already said, things like KPI problems appear to remain. We can increase the staffing, and I remember your question, Chair, about moving the ratios around, because in the same way as you move the ratios around in open prison and closed prison, think about the fact that immigration detention has a different purpose and has different needs and has a different cohort. We can do that. We can introduce better work or better activities. We can train staff in mental health and capacity. We can put prompts on ACDT forms that then link it into the 35.2 report. We can do all of those things. Energise the IMB or the other monitors. But we submit that none of that is likely to be enough. All of those things have been done or said before, and all of them are capable of being sliding when the spotlight moves away, and they will fade as the energy fades. Or when you get the pressure, small boats, Dublin. You remember the 2020 IMB report and the Observer and the Liberty material. It's telling you what it's like yet, what it's like certainly in 2020. And what Mary Molyneux told you, they were clearly not coping in 2020 with suicide and self-harm, is what she told you. Ian Castle was asked about that IMB report, was said that treating the whole detention estate inhumanely, and he said he couldn't disagree. The numbers are down at the moment, but Mr. Hewer told us, unsurprisingly, in his oral evidence that he expected an increase. What will happen when that increase comes? Mary Molyneux again, she told you that the Home Office kept, this is the time of the Dublin Convention situation, the Home Office kept bringing these men in, the Home Office were aware of the problem, the Home Office knew this was happening, the numbers of self-harm. And then she said, the reply that she got, she said, was all about process. We have the right, we have the process, and then she said there was just a total disconnect and not, in my view, acknowledgement of the problem. That's what they do. That's what the Home Office seems to do on that evidence. They plough on. Now, the other thing I just mentioned, I would single out for special mention, is that yes, you could look at what you can do to change the culture. But in order to change the culture, as a number of witnesses told you, you would need clarity of purpose and a recalibration of the purpose in favour of detained person welfare. And Professor Bosworth talked about that. She talked about how hard it was for DCOs in circumstances when the purpose of the detention was not clear to them. The Jill Dando Institute said the same thing. You have more clarity of purpose in a prison because it's about punishment and rehabilitation and release. So you know what that is for. But immigration detention is much more difficult, and it's difficult for this reason, because it does need openness and honesty about what it's really about. The problem with immigration detention is there's just no point in pretending it's about a short period of detention just in order to effect removal, because you know that's not in fact what's happening. As soon as you look at the release statistics, you see that the numbers are very low. The only reason the release numbers are anywhere is because of, essentially, when you look at the numbers, you've got places like Poland and Romania where there is a probability of removal. But in relation to all the tricky countries, if I can put it informally, when you look at places like Sudan, Syria, Afghanistan, Iraq, Iran, also coincidentally the countries where the people coming from there are most likely to be most damaged, the removals in relation to those countries are very low. The latest statistic, below 5% for all of those. So this isn't really about removal. And all that is happening is the Home Office is pretending it is. And once it does that, as it ploughs on, believing or wanting to believe that it is in fact about removal and that all of these people are off and all of these people are charlatans and they're maintaining claims to remain which are not real, then that fosters the abuse. Because as long as you maintain that you're on the way out, it informs the language of why don't you fuck off home. So, yes, look at that. Yes, see if we can do that. Yes, see if we can bring some honesty and transparency to bear about what the real purpose and function of immigration detention actually is. But are we going to achieve that? Are we going to get there with that? Is that a realistic thing that we can alter given the political rhetoric and everything else that we have around this area? And the problem that we have, and the people that I represent have, is that absent something really hard and robust and fundamental, we can do all of the work around those softer issues, but it won't actually produce the outcome that we need. And what you need to do is just get much shorter periods of immigration detention or no immigration detention at all. Professor Bosworth has told you, and it's very interesting the timing of all of this, is that the pandemic has shown that much larger numbers can be managed in the community. We have not. There's no evidence that we have seen that suggests that the pandemic and large numbers of people being managed in the community has produced an escalation in absconding or offending. There's no evidence of that, and if there was, we'd expect the Home Office to produce it because the burden of proof in detention is on them. Absent that, we're entitled to infer that much larger numbers of people could be managed in the community. But what you are also being told is why not do time limits? Now, I understand that it will be said that this is outside the terms of reference, but is it? Because the terms of reference say, examine the reasons for the mistreatment and the experience. And the reasons for the experience, at least in part, is a lot of people are telling you, the detained people are telling you, that indeterminate detention is making the experience worse for them. At the same time, as Mary Bosworth tells you, it's making it harder to respond to them because it's undermining the clarity and the purpose of immigration detention. So one does have to reflect what the evidence is telling us, and that is what it is telling us. Even Jerry Petherick said, in his oral evidence, I think the real issue, and you're right, I'm not a clinician at all, but my experience would say that the real issue that impacted on detainees' well-being and mental health was their sense of not knowing the uncertainty of the situation. When you have that consistency of evidence all saying the same thing across these different kinds of witnesses, then we need to do something about that. We need to take it seriously, and we certainly need to record it. Equally, why isn't indeterminate detention a method, policy, practice, or management arrangement that causes or contributes to any identified mistreatment? That is something that you're tasked with looking at within your terms of reference. It seems to us that it is amply wide enough for indeterminate detention to be a contributing practice, and therefore within the terms of reference. Equally, your scope determination, 6th of January, confirms you can make any recommendation you like. You were clear in the scope determination that you would be flexible and go where the evidence takes you. That is where we say the evidence is taking you. Too many people from too many different stripes are saying the same thing. You are unconstrained, we say. And again, we say, look at the scale of what we've seen. You should respectfully do all you can about it. If not you, then who? And if not now, then when? And don't succumb to the siren song of Mr. Blake, who told you, who's not here to hear, who's not now in the room to hear me say this. Mr. Blake said in opening, don't go into the politics. The things that Brook House require is mundane. Don't do that. It's impossible to avoid politics. We're talking about immigration here. Certainly stay off the mundane. Certainly let's go beyond mundane. So, a couple of other things, very briefly. If Brook houses are to continue, the mentally ill need to be out. They just need to not be in Brook House. They need to be not in detention. Not just those who can produce a certain calibre of medical report that just results in the Home Office then complaining about there being too many medical reports. We don't like the medical reports because they all say that these people are ill. Well, there may be a reason why they say that. We know that you can't do therapeutic work in the centre. All of the doctors say that. And not just the mentally ill, all the vulnerable need to come out. Trafficking victims, torture victims, all of them. Bring into the systems those who understand the experience of detention, and that may be GDWG, but it also means the former detained people themselves, because that will bring them closer, that will foster understanding, it will foster empathy and care, it will do more to understand the detained person experience that has not so far been well understood. And stop, absolutely stop, using this building to detain people for any length of time beyond the 72 hours for which it has been designed. Chair, there are other longer lists of recommendations, and they are contained in the fourth witness statement of Anna Pincus, who I represent, in the GWG, but there is also more from BID, from Detention Action, from Medical Justice. You've got long lists of recommendations. I can't improve on all of those. You have all of those, and we'll put them in our written submission. But there is a reason why all of those people agree. They all know their own bits of the system, and they all agree, and there is a reason why they agree. And I conclude simply by saying again, go where the evidence takes you. Now is the time. Be bold. Thank you very much.
Thank you, Mr. Armstrong. Thank you. Mr. Stanton,
Thank you, Chair.
do you require the lectern or anything?
No, I'm fine, thank you.
Okay, thank you.
Chair, I'll be giving the closing statements on behalf of Owen Syred, who's in attendance today and sat beside me. At the outset, Mr. Syred would like to say that he has followed the evidence of the inquiry closely and has been disgusted at the actions and attitudes of some staff which demonstrated a lack of humanity towards people in their care. He regrets not having done more to counteract these behaviours at the time. He would like to commend the bravery and resilience of those formerly detained persons who have provided evidence to the inquiry. As Mr. Syred said in his opening statement to the inquiry, he welcomes the inquiry's scrutiny and continues to be hopeful that the inquiry's findings and recommendations will lead to significant improvement for those who are detained within immigration detention centres like Brook House, but also for the people who work in these centres. This closing statement is focused on issues that concern staff and management at the centre, which is where Mr. Sared feels that he can add the most value. It will address 6 areas as follows. First, dysfunctional leadership. Second, recruitment. Third, training. Fourth, career progression and professional standards. Fifth, the impact on staff of working at Brook House. And sixth, balance. First, dysfunctional leadership. Part of the reason for addressing this area first is because the leadership is responsible and accountable for the behaviours within the centre, but also to highlight at the outset an issue that Mr. Sared believes runs throughout the whole of Brook House, including the senior leadership, namely the lack of clarity and awareness about the fact that immigration detention is not a punitive measure, but a means of facilitating immigration controls. There are some features of immigration detention at Brook House which are clearly punitive without any obvious justification, such as being locked in a room with strangers for 11 hours a day. There's also a very obvious tension between the caring element of ensuring the welfare of detained persons and the reality of immigration detention, including the need on occasion to use force. It was striking the number of occasions that staff spoke when giving oral evidence about their empathy with detained persons, which Mr. Sared believes is on the whole genuine, only to be confronted with recordings of their actions and statements which evidenced authoritarian, aggressive, abusive or uncaring behaviour. Some staff appeared visibly shocked while giving evidence of being confronted by their own behaviour. Mr. Sared believes that the lack of clear direction from senior leaders as to the purpose of an immigration detention centre, most particularly that it is not to operate as a punitive measure, is at the heart of the problem, coupled with the fact that the majority of staff were inexperienced and without adequate training. Mr. Sared has always been aware that there were 2 camps within the DCO and DCM staff. Those like Mr. Sared who believed that their role and priority was to ensure the welfare of detained persons, and those who believed that Brook House should be run more like a prison. However, having engaged with the inquiry proceedings, Mr. Sared now realises that this fault line also ran through the senior leadership team. The inquiry has heard how there was a lack of cohesion among the senior leadership team. Lee Hanford referred to the toxic relationship between senior management, to an element of chaoticness, to the fact that the relationship between the centre director, Ben Saunders, and his deputy up to 2015, Duncan Partridge, had broken down, and that other staff knew there were 2 camps on site. The statement of Michelle Brown refers to a clear lack of trust within the senior management team. Mr. Sared believes that Ben Saunders was out of his depth and did not command the respect of his senior leadership team, which was in part due to his social care background. There were many within the senior leadership team who saw Mr. Saunders as too soft and wanted to see the centre run more like a prison, such as Duncan Partridge, Steve Skitt, Jules Williams and Ian Danskin. The prison approach was too ingrained within many of the senior leadership team, and this filtered down through the whole organisation and resulted in the promotion of individuals who shared these values and contributed to the us and them culture. Attempts to lighten the prison-style environment were opposed, and the less austere atmosphere at Tinsley House was referred to by some senior managers, DCMs and DCOs, as Disney House. Mr. Sared believes that Brook House suffers from an identity crisis, for which the senior leadership team bear a significant responsibility. In addition to this specific and profoundly damaging failure, the staff at Brook House were generally not well led. Brook House is not a particularly large workforce, and almost all staff are required to be physically present to carry out their work. it should not have been difficult to instill a positive, supportive team ethos and to communicate important messages such as the importance of freedom to speak out and to create and reinforce positive shared values. An example of the ineffectiveness of the senior leadership team is the failure to support Mr. Syred when he reported the fact that he was being bullied following his report of a racist incident. You will recall, Chair, that a poster which contained photographs of staff so that they could be identified within the centre had been defaced next to Mr. Syred's image with the words, quote, grass, close quote, and post-it notes were also placed over his locker stating, quote, N-word lover, close quote, and, quote, grass, close quote. Such an appalling example of bullying in support of a member of staff who had engaged in racist behaviour ought to have resulted in an immediate, visible and unequivocal response from senior leadership, including clear communication to the workforce that this type of behaviour is unacceptable, an investigation to identify those responsible, and a review of processes, procedures and training so that the staff were in no doubt of their responsibility to call out inappropriate behaviour, and that the more senior the member of staff, the greater their responsibility to call it out. Instead, nothing was done other than the provision of hollow expressions of support. The fact that inappropriate behaviour was not routinely challenged by the senior leadership team and managers led to staff feeling empowered to behave inappropriately because they knew that there would be no consequences. The lack of proper recruitment, training and induction processes, which will be mentioned in more detail later in this statement, was also a significant failure of the senior leadership team, as was the lack of presence and visibility and any real insight and awareness of what was happening on the shop floor. There were no proper mechanisms for feeding the views and experiences of DCOs and DCMs into the senior leadership team, and worse, suggestions for improvement and expressions of concern were actively suppressed. An example of this within Mr. Syred's first statement, that ironically occurred at a staff forum, concerns Mr. Syred's attempt to discuss what he considered had been an unnecessary use of force to facilitate a transfer, which had caused injury to a detained person, and to suggest that in future, officers who may have a positive relationship with a detained person be afforded an opportunity to explain and persuade the detained person to transfer without the need for use of force. This is the same type of engagement that the inquiry's expert witness, John Collier, indicated when giving evidence was not happening enough at Brook House. However, Mr. Syred was told by Ian Danskin, who was chairing the staff forum, that it wasn't for discussion. The inquiry has heard a lot from staff witnesses about the fact that bad language was rife within the centre. Some staff continued to seek to justify its use, whereas others had come to realise that whatever poor language and abuse they faced while working at Brook House, it was not acceptable to respond in kind. Given the relative inexperience and lack of training of many of the staff, it's understandable that they responded in this way. However, it was the job of the senior leadership team to ensure that staff behaved professionally through training, messaging, monitoring and role modelling. And again, in this regard, they failed. Second, recruitment. If staff are not interested and concerned at the conditions and circumstances in which people are detained and do not have an interest and concern for the individuals that they are caring for, then they won't be motivated to do a good job. Motivational fit needs to become a central plank of the recruitment process, and more emphasis should be placed on identifying people who will take pride in their roles. Mr. Syred experienced verbal abuse and was sworn at and assaulted on a number of occasions for relatively modest pay. But he stayed because he enjoyed the work, particularly the interaction with detained persons, and he felt that he was making a difference. He is not alone in this view, and with more effort, a higher number of candidates with these values can be identified. Assessment days for recruitment were often staffed by people such as Graham Purnell and Derek Murphy, both of whom face allegations of violent behaviour against detained persons. This is yet another example of the inappropriate emphasis and value placed on control and restraint and the macho culture at Brook House. Mr. Syred applied to run an assessment day and was turned down, which illustrates that the values he promoted and his caring approach to detained persons were not regarded by the senior leadership team as attributes to look for in new recruits. There is a need to identify and attract staff who will treat the role as a career and not as a stopgap for something else, as was too often the case and which resulted in staff who were content to do the bare minimum. Some suggestions for how this can be achieved are made at a later section in this statement. The inquiry has heard from a number of staff witnesses that the reality of the role was nothing like advertised, and that many staff left soon after they started, once reality had dawned. This is a huge waste of recruitment and training resource, and another aspect of a flawed recruitment strategy. Mr. Syred believes that there is a need for a much more robust assessment process to identify and attract people with the right skills who are interested in undertaking the role for the right reasons. The assessment process should continue both through the initial training course and a properly assessed, not just time served, probationary period. Third, training. The inquiry has been repeatedly told that the initial training course did not prepare staff for the realities of the job, which, similar to the failure to accurately advertise the role to identify the right candidates, makes no sense because time and money is wasted on training staff who often leave shortly after starting once they become aware of the reality of Brook House. On any level, the role of a wing DCO, as someone who is required to safeguard the welfare of approximately 100 detained persons, together with only one or two colleagues, taking account of physical and mental health issues, the ACDT process, drugs issues, and incidents of violence and bullying, as well as contending with verbal abuse and threats of violence, is an extremely challenging position, and to perform the role properly, there needs to be significantly more and better training. Given the high levels of incidents of self-harm and mental illness, it is a particularly shocking failure that more training and insight into mental health was not provided to the staff. Some staff have told the inquiry that they received no mental health training. Mr. Syred believes that they are mistaken in this regard. However, the fact that many staff do not recognise that they received mental training at all speaks volumes. Mr. Syred had been a little puzzled at some criticisms of staff during inquiry proceedings for comments made while engaging in role-play scenarios, because the whole point of role-play training is for it to be as realistic as possible. The language used by detained persons could sometimes be threatening and abusive, and there is a need for this to be reflected in the training. Mr. Syed suggests that there should be more scenario-based training and that staff should be confronted in group learning sessions with how and how not to behave in the difficult and challenging circumstances that they will inevitably encounter. Mr. Syed would also recommend that there should be an opportunity during the initial training course for engagement between trainees and detained persons, perhaps former detained persons if they would be willing to take part in such a programme, to better help trainees see detained persons as individuals, to gain a better insight into the impact of detention, and to establish and build empathy. Staff must be better equipped to meet the complex needs of detained persons. The range of needs is huge, from short-term stays by people who have overstayed their visa and wish or do not object to a return, to people who suffer from serious mental health issues and may have suffered torture and persecution. There are also significant numbers of detained persons who are liable to behave aggressively and violently or to self-harm. Mr. Syed felt it necessary to undertake additional training at a 2-day course on immigration law delivered by Amnesty International to gain a better understanding of the legal issues involved in immigration, and so that, as a DCO, he was better able to engage with detainees who were subject to the legal process of removal or deportation. As a result of this interest and commitment, Mr. Syred was able to assist a detained person who had been described by officials from his home country as an abomination because of his sexuality. Mr. Syred spoke about this in his evidence before the inquiry. It is accepted that it is not the role of staff at immigration detention centres to advise detained persons about their claims. However, given the context of immigration detention and the length of time that some detained persons spent at Brook House, there is a need for better training on the basic principles of immigration law in order to effectively carry out the role of DCO and DCM. Training is also largely based on the National Offender Management Service training, which is designed for prisons and not immigration detention centres. The rules governing the running of a prison and an immigration detention centre are different, and there are a number of other factors that make the role of a prison officer and that of a DCO and DCM very different, including the uncertainty around the length of detention, the mixed population of detained persons who've been convicted of serious criminal offences with overstayers with no previous experience of detention, and freedom of association and movement, at least during the day, which requires a different set of skills to manage. An example of the inadequacy of the training provided is the fact that Mr. Syred was never trained in the operation of Rule 35, which represents a significant failure given the importance of this provision, as has been emphasised in the inquiry proceedings. It was only when he started working in welfare, several years after he started at Brook House, that he learned about the requirements and significance of the rule. Fourth, career progression and professional standards. There needs to be an opportunity to progress within the DCO grade so that the centre can build a reservoir of experienced and committed practitioners as well as managers. Mr. Syed had no ambition to become a DCM. However, it was the only way to achieve career progression. He wanted to carry on and develop his role as a welfare officer, which allowed him to assist people on a daily basis. Mr. Syed believes that the introduction of a senior DCO role to allow for career progression, development and job satisfaction would improve standards within immigration detention centres and also greatly improve staff retention. The lack of financial remuneration for experience and commitment to the role also needs to be addressed. As a 10-year served DCO, Mr. Syed was earning the same salary as a new recruit with no experience, which was a source of frustration and needs to be addressed in order to retain people with the right skills and experience. As an example of the benefits of experience, Mr. Syed's reaction when he first started working at Brook House was to become offended by abusive comments or aggressive behaviour by detained persons. However, he came to recognise that it was the detained persons who were locked up while he was not, and to see past such behaviours as isolated incidents, realising that the detained person was in a stressful situation or perhaps having a bad day. The inquiry's counsel team have highlighted this imbalance of power and the duty on staff to behave professionally at all times, even in the face of abusive and aggressive behaviour. However, it can be particularly difficult for inexperienced or immature staff to do so, particularly without effective and reinforced training and the availability of experienced role models such as Mr. Syed. DCOs and DCMs should be recognised as a specialist profession, not the cheap cousin of prison officers. A recognised qualification tailored to immigration detention centres should be developed and become mandatory for those seeking to work in the centres. This would provide staff with a sense of pride and professional duty. Fifth, the impact of working at Brook House on staff. Professor Bosworth spoke about the secondary trauma experienced by DCOs and DCMs when confronted by the trauma suffered by detained persons. And many officers and managers have been adversely affected by their experiences at Brook House. The evidence of Professor Katona has prompted Mr. Syred to reflect about the challenges of seeking to support people in dire need without the appropriate knowledge, training and support, and the detrimental impact on how staff cope and work with people with mental illness. Working at Brook House, you are exposed to high levels of aggression, abuse and violence, and Mr. Syred has been assaulted on a number of occasions. There is a need to be hyper-vigilant to respond to drug misuse, violence and threatening behaviour, and this can cause mental health problems for staff, particularly when the training and support is inadequate. Mr. Syred has been diagnosed with post-traumatic stress disorder, and when he tried to raise his own mental health issues, the management of Brook House wouldn't listen. The strain of working at Brook House led some officers to hide their lack of confidence with bravado or to act out of character in order to fit in. And the inquiry heard a particularly distressing example of this when Mr. Sanders gave his evidence. Staff were also frustrated by staff shortages, the lack of support from senior management, and by colleagues who were not pulling their weight, leaving staff who took the role seriously to become overwhelmed and dispirited by not having sufficient time to do their jobs properly. Sixth, balance. Mr. Syred's main aim as a core participant is to tell the inquiry what it was really like at Brook House. The inquiry has seen and heard about the worst of Brook House, but there is also another side which was not shown in Panorama or drawn out in the inquiry hearings. It was a small minority of staff who conducted themselves as Jan Pascali and Derek Murphy did. By and large, staff at Brook House behaved well and treated residents with care, dignity and compassion. There are no recordings of officers and detainees chatting, having a coffee, sharing a joke or playing pool. However, these were everyday occurrences at Brook House. In his evidence in December last year, Mr. Syred told the inquiry, "When you worked on a wing with guys, you got to know them, they got to know you. It felt like you were almost a community. Believe it or not, I've had some very funny times joking and laughing together." Lee Hanford told the inquiry that the behaviours you see from the majority of staff, their relationships with detainees, were excellent. A number of officers and managers have told the inquiry about the efforts they made to build relationships with detained persons and to look after their needs. The inquiry has also heard evidence of officers seeking to support detained persons by helping them with forms and documents needed for immigration cases and assisting with access to legal representatives and charities. Mr. Syred can recall numerous examples of caring and supportive behaviour by staff, such as a welfare officer colleague, Nikki Madgwick, who arranged for a detained person's dog to be cared for by a canine charity. James Begg, Safer Custody Manager, who provided detained persons with his contact number so that they could contact him 24/7 if they had thoughts of self-harm. Ramon Giraldo, a highly respected and well-liked colleague who worked tirelessly to provide activities for detained persons with the limited resources available to him. Michelle Brown, who attended Surrey Hospital Accident and Emergency with an Egyptian national who required specialist treatment for mental health issues and stayed at hospital all night to support him. And Mr. Syred's colleagues in welfare, who all went the extra mile on a daily basis. There are also many officers who Mr. Syred believes were caring individuals who were shown in the BBC recordings behaving inappropriately. For example, Charlie Francis, Steve Webb, Calvin Sanders and Clayton Fraser. Mr. Syred has known some of them for years and witnessed them trying to do their best. In his evidence to the inquiry, Mr. Syred described Clayton Fraser as someone who he had always witnessed being quite caring, considerate. To me, that was quite really out of character, but I do believe that was probably more just to fit in, just to be accepted, and it's a very common thing. The inquiry is understandably focused on a small selection of the recordings made by Callum Tully. However, they do not present a balanced picture of life within Brook House, which is a point recognised by Professor Bosworth in her expert evidence to the inquiry. It is important to Mr. Syred that the inquiry has a balanced view of what Brook House was like, and that it should find some way of recognising the many positive interactions that took place between staff and detained persons. Mr. Syred is conscious of the distressing experiences that many detained persons experienced. However, not all allegations made by detained persons are accurate. For example, the witness statement of D390, submitted to the High Court, that referred to the use of batons by staff in circumstances where video evidence demonstrated that this was not the case. There are other examples, and a careful examination of the available facts is needed when assessing the merits. Mr. Syred would also ask the inquiry to take account of the fact that there have been significant improvements in the conditions at Brook House between 2009, when Mr. Syred first joined, and the relevant period in 2017, so that recommendations can be made for the future, having regard to relevant past developments. In his first witness statement, Mr. Syred states, "When Brook House first opened in 2009, it was a dreadful place. 90% of the detainees were foreign national criminals, and it was infested with drugs. There were also problems with prostitution, bullying, and gambling. It was a very menacing atmosphere which you could cut with a knife." Some of the factors that Mr. Syred believes contributed to the problems in the first few years were the fact that the overwhelming majority of residents were time-served prisoners, the failure to allow the centre time to bed in. Almost immediately it was opened, it was filled with residents, and an even less experienced workforce than in 2017. Less recreational activities were available, and the fact that all wings were open to each other, which caused considerable disruption and violence. The atmosphere changed completely from 2009 to 2017, and you could not compare the two periods. The main reason that conditions and behaviour improved was because staff were able to build positive relationships with detained persons. And Mr. Syred suggests that a continued focus in this area will lead to further improvements. Finally, Mr. Syred would like to suggest two other broad areas for improvement. First, an independent state-run service to better ensure the welfare of people in immigration detention. In Mr. Syred's view, the role of a DCO and DCM is far too important for it to be left to a private company whose priorities are to profit and shareholders. Mr. Syred also has concerns about the need of any private company to protect their corporate image and the disincentive this brings, conscious or not, to seek to identify poor practices and areas of concern by thorough investigation and external reporting so that issues can be addressed and improved. In Mr. Syred's experience, staff rarely have loyalty to private companies. However, they will take pride in what they do if they feel they're able to have a positive impact on the circumstances of detained persons and their families, and they are able to positively influence management of the centre. Second, the act of locking someone up for 11 hours each day, either alone or with one or more other detained persons, is stressful and damaging to mental health and well-being. It is also punitive in nature and cannot said to be in any way necessary to ensure lawful immigration controls. There is no reason that detained persons could not be provided with their own key, with wing officers being able to access rooms that are locked from within when necessary. This is a practice adopted in other countries, notably Norway, and the current low numbers of people in immigration detention would be an ideal time to trial it in the UK. One has only to imagine how it would feel to be locked in a room for such a long period of time each day to begin to appreciate the levels of anxiety the practice causes. The fears of detained persons about being locked up at night were very obvious to Mr. Syred. Staff would spend considerable time persuading people to be locked up together with a stranger, and when detained persons refused, they would be taken to the care and separation unit. For people who have difficulty sleeping, which is very common in those who are experiencing stress and anxiety, it would be far better for them to have access to communal areas and to be able to undertake an activity rather than lying in bed with negative thought patterns. Staffing levels would need to increase, but not significantly, and the additional cost would be a small price to pay for the potentially significant improvements to the well-being of those in immigration detention. And a final point, picking up on what Mr. Armstrong said about a hostile environment. Mr. Syred can confirm that he was encouraged to make known the hostile environment to detained persons. Thank you, Chair.
Thank you very much, Mr. Stanton. Mr. Kelly, we're going to be hearing from you next, but I'm going to suggest that we take our 15-minute break and that we'll hear from you when we return at 3:45.
That's fine.
Thank you. Thank you very much. 3:45. Mr. Kelly, thank you.
Thank you very much, Chair. I propose to just deal with effectively in a thumbnail sketch with the submissions that we are making, because we will be making full written submissions later dealing with all of the points. The very first point I would like to make is that in Section 2 of the Inquiries Act 2005, it provides at subsection 1 that an inquiry must not rule on and has no power to determine any person's civil or criminal liability. It is an inquiry, not a court of law. No one is on trial. Subsection 2 provides that an inquiry is not to be inhibited in the discharge of its functions by any likelihood of liability being inferred from facts that it determines or recommendations that it makes. The use of the word inferred clearly refers to subsequent litigation, thereby reinforcing the point. In respect of Article 3, it of course prohibits torture, inhumane treatment and punishment. We say in short that there is no credible evidence that either Nathan Ring nor Stephen Webb, as individuals, engaged in such conduct. The thrust of the allegations against them is the use of foul language on limited occasions. Brook House, it has got to be said, was an exceptionally difficult environment for everyone involved: detainees, employed custody officers and other employees alike. It was, on virtually all accounts, a building with physical inadequacies, with poor facilities, a building which suffered from overcrowding, and a place which was under-resourced and understaffed. Looking at just some of those things briefly, it could be said to be a poor environment, and there was certainly uncertainty as to how long the detainees would be kept prisoner in Brook House, and that contributed, we say, to its problems. The cells weren't kept clean, there was poor ventilation, some exercise areas were closed, the exercise space was far too limited, and that's just according to Jeremy Petherick of G4S. Mr. Singh from Her Majesty's Inspectorate of Prisons had this to say, but I think one of the major ones is the fact that, this is in relation to Brook House in particular. It is a centre which looks and feels like a prison and is designed like a prison. As we have said many times, that's inappropriate for a detainee population. The length of detention was uncertain, or put another way, detainees were subject to indefinite detention. That had a serious impact on the detainees, and indeed created an atmosphere leading to frustration and aggression, all of which contributed to the problems this inquiry is examining. Professor Mary Bosworth also identified the length of time detainees were held in centres such as this as a problem, which, among other things, contributed to the detainees' poor mental health. If people are subject to a regime where they don't know how long they will be detained, it is hardly surprising that there will be anger and frustration. Brook House was overcrowded. There is a significant amount of evidence that Brook House was overcrowded, and that was certainly not helped by putting in a third bed in many cells in early 2017, the so-called 60 extra beds. The independent investigation into concerns about Brook House by Kate Lampard and Ed Marsden used 3 words about it.
I'm sorry, Mr. Kelly, I think we've lost your microphone. Could you just give us a moment and we'll see if we could get that?
that working?
That's better, thank you.
Thanks. Do you want me to repeat the last bit, or have you got that?
If you could start again when you were going to start talking about the independent investigation.
Yes, I'll
by
do
Kate
that.
Lampard, if you want to start there. I think we lost you then. Thank you.
The independent investigation into concerns about Brook House by Kate Lampard and Ed Marsden in November 2018 described it as overcrowded and unsettled. Brook House was under-resourced. Footage of Callum Tully looking for an evacuation chair, but there weren't any to be had, nor were there any where they were supposed to be. In any event, Brook House didn't have enough evacuation chairs. There was a group complaint submitted by detainees regarding the lack of internet access. There was a lack of translators, long queues to use IT equipment, or access to the welfare office. There was no clean bedding, often no cleaning equipment provided, officers unable to provide basics such as toilet roll, not enough showers for the number of detainees, poor internet, poor phone signal, malfunctioning phones, and poor quality food. Brook House was also understaffed. As Nathan Ring put it, the Home Office contract was, I believe, very prescriptive, particularly in terms of how many hours G4S would be paid for. Staff on the ground, however, generally felt that Brook House was understaffed. On a good day, we were lucky to have 50 officers in the whole centre. On evenings, you might be lucky to have 6 DCOs and 2 DCMs. It left staff on the ground of the centre often feeling vulnerable, overworked and uneasy. However, there was a high turnover of staff because a lot of the candidates were inexperienced. Some candidates never came back following the training course, or decided that after a month of working in the role, it was not what they expected. It was the residential side which suffered the most with retaining staff. The consul to the inquiry, Mr. Altman, on the first day, seemed to recognise this when, in opening, he said, "You may want to consider whether the range of staffing problems described contributed to dissatisfaction amongst detained persons and a growing feeling of hopelessness and frustration among them, which in turn had an impact on the levels of self-harm, substance misuse and violence at Brook House. The more challenging or non-compliant detained persons became, in consequence of their environment, the more some staff resented them for the additional work and stress this added to their lives. Understaffing and overwork were also reported to affect staff morale in a direct sense. Much has been said about the use of foul language. However, we cannot treat Brook House as a normal workplace, like an office. Swearing was on the evidence, a common method of communication, and was not intended to be offensive. In many cases, it appears that such swearing was speaking to detainees in the common language in use by staff, including, in fact, Callum Tully, and detainees on occasions. As Mr. Ring in his evidence said, such language often was a coping mechanism for many in Brook House. Now, when it comes to the inquiry considering the role of Callum Tully, you should bear in mind the evidence of officers such as Jan Pascali, who described Callum Tully as always fishing for stories. He told you how he, Mr. Pascali, responded by making up stories and how he embellished the stories. You should also bear in mind Callum Tully's own evidence that he only turned his camera on when he thought he would capture interesting material. That footage should not be treated as intrinsically representative of everyone at Brook House. The true ill treatment and cruelty at Brook House lay in the indefinite nature of the detention. That was the root of all the problems. The fact that it was designed and supposedly intended to house people for a short term pending their removal from the United Kingdom. And I personally, and I think many others in this room are still in the same position, whether it was 28 days, 72 days, or 72 hours, and if so, when that changed, none the wiser after the evidence heard. But whatever it was, through Home Office failings and inefficiency, the detention of its residents stretched to many months in some cases. The Home Office, in the form of Mr. Phil Riley, characterised the notion of detention for no more than 72 hours in Brook House as an urban myth. That uncertainty as to how long an individual might be deprived of his liberty led, inevitably, to frustration on the part of those detained. This was recognised by Jeremy Petherick on day 34 when he said, "The real issue that impacted on detainees' well-being and mental health was their sense of not knowing what was happening with them and the frustrations of their progress towards their release, either into the United Kingdom or their repatriation. And so the major impact on their well-being was the uncertainty of the situation they found themselves in." The problem in our submission is the system. It would be an error to scapegoat the former employees and put events down to a few bad apples. Such an approach would do nothing to address the issues which have given rise to the need for this inquiry, and would not address what has been dealt with by a variety of different witnesses. In short, such an approach would be no more than a cop-out with little credibility. The two men we represent, Nathan Ring and Stephen Webb, if guilty of anything, are guilty of little more than a few facetious comments, silly comments, which were made in what they thought were private conversations. In short, the staff must not be portrayed as the scapegoats, nor are they self-evidently responsible for immigration or deportation policy. They merely worked in a dysfunctional system. It is, we submit on the evidence, clear that many of the problems with Brook House were and are due to indefinite detention as a policy, combined with housing detainees in what in effect was a prison with extremely limited facilities, understaffed, under-resourced, badly managed. And the responsibility for that should be laid where it belongs, at the door of the Home Office and its contractors, here, G4S. Thank you, Chair. I'm glad to say that I finished well within time.
Thank you very much, Mr. Kelly. Mr. Jacobs.
Chair, I represent Charlie Francis, and I'm instructed by Howe & Co. Charlie Francis was a DCO at Brook House from 2012 and during the relevant period, and he appears in the Panorama programme. I don't propose to deal with the evidence at length today, and we'll do that in more detail in the written submissions. Mr. Francis gave evidence on day 23, the 3rd of March 2022. He became a court participant on the previous day, so you don't have opening submissions in respect of him. Mr. Francis would like the inquiry to know that he's watching today on the live link. He can't be here this afternoon. It's important that I say from the outset that Mr. Francis does not seek to excuse his behaviour towards D1527 and D728, as shown on the Panorama programme. He accepted in his evidence that he was shocked when he saw that programme and couldn't believe, he said, that he was seeing himself. Generally speaking, my client was a capable and competent DCO. He had no antipathy towards those detained at Brook House and told the inquiry that he treated detainees as human beings. He also told the inquiry in his evidence that he intervened on 2 occasions to save detainees who had tried to kill themselves, and the detail of that is detailed in his witness statement. DCM Webb referred to Mr. Francis when he gave evidence on day 26, and he said, "Charlie was a good officer. He was a very good officer who I relied on a lot, and I'm sorry that he got tied up in what I said." And the core participant Syred, who is to my right, Owen Syred said, when asked about the officers on E-Wing who were macho and cliquey, he said, "Yes, most of the guys apart from one, Charlie, I knew very well. He was always very good with detainees." But Mr. Francis is shown on the Panorama programme making inappropriate remarks towards D1527 on 25th of April 2017 and using inappropriate language towards that detainee in the aftermath of the Pashali choking incident, an incident which my client has described in his evidence as horrific. My client accepts that he used the words, "Are you going to continue being a tool? Are you a man or a mouse? Are we getting bored with this now?" He said that at the time he used those words believing he was bringing D1527 out of a state of anxiety to bring him back to reality, in his words. He confirmed in his evidence, when asked by Mr. Altman, that he now understands that he was unable then to distinguish between a detainee who was capable of rational actions and a suicidal man who was suffering from mental illness. Mr. Francis received no training in mental health or PTSD awareness. And in the absence of such training, he believed at the time that he was able to distinguish between those who he believed were genuine people who wished to harm themselves and those who he thought at the time were in attention-seeking. Mr. Francis's position, looking back and reflecting, is that had he been appropriately trained by G4S, he would have acted entirely differently towards D1527. And the same lack of awareness in relation to mental health issues applied to my client's exchanges with D728 on the 6th of July 2017. The video footage shows my client arguing with this detainee who had been trying to frustrate officers by covering the observation hatch with tissue paper and had been complaining about lack of access to medication. Mr. Francis was heard to say to the detainee, "If I have to come back again, you won't be going anywhere today. You will be staying down here permanently. Do you understand?" And after they were out of the detainee's earshot, Mr. Webb used derogatory language, saying he would like to punch the detainee. He made it clear in his evidence that the detainee couldn't have heard that, and Mr. Francis replied, "If you don't, I will." Mr. Francis accepts there is no excuse for his behaviour, but again, he was not able to understand that D728 was a man who had significant mental health problems. Mr. Francis' primary problem here is that he was not properly trained to deal with detainees with mental health and PTSD issues, and that is a systemic failing at Brook House. Neither was my client trained or equipped to deal with the negative, macho, aggressive culture that had been allowed to develop and fester at Brook House. Sarah Newland, in her Verita interview, referred to a large cadre of DCMs who are testosterone-filled. And Mr. Francis stated in his evidence that there were 2 categories of staff members at Brook House. Some, in his words, were very hard-nosed, uncaring types without compassion or softness, and he confirmed that that certainly included Jan Pashali, who, in his view, shouldn't have been working on E-Wing. The second category were officers who, like my client and Mr. Syred, were more human, more sympathetic, and more placid men. In Mr. Francis's case, the former group prevailed over the latter. Mr. Francis agreed in his evidence that he was one of those who was easily led by more dominant staff members. He was led into behaviour by other officers, but did not instigate that behaviour. The Reverend Ward has made the same point in his evidence to the inquiry. He described my client as someone who did not have bad intent, but an example of someone who was caught up in the culture of Brook House, and goes on to say that in both the incidents in which Mr. Francis is featured in the Panorama programme, he took inappropriate action and used inappropriate and offensive language when in the company of more dominant staff members. But, Chair, this is as far as it goes. It is important to note that Mr. Francis, when giving evidence, clearly and categorically rejected any suggestion that he tried to cover up Pashali's conduct, or that his reluctance to give a police statement over and beyond the information that he'd given in detail to G4S represented any attempt to protect Pashali from prosecution. And we respectfully say that there is no proper basis for the inquiry to make any finding along the lines that my client was involved in any cover-up, aside to what is said about the inquiry not being able to or make findings in relation to liability. But that's an important point for my client. We agree, and we say that there is broad agreement amongst the core participants' representatives that the evidence has shown that the problem at Brook House was not one of bad apples, or as Mr. Brockington for G4S suggested, isolated incidents. The problems at Brook House in the relevant period arose from systemic failings, as Dr. Patterson has said, a corrupted culture. And ultimately, it was the responsibility of G4S and the Home Office to secure the welfare of detainees at the facility. And the systems in place at Brook House failed to do this. Chair, like Mr. Stanton before me, I will address you on 6 issues, 6 areas. The first area, which I've already touched on, is lack of mental health training. Mr. Francis stated in his witness statement that when he attended DCO refresher courses, he would say that officers needed to receive psychological training to understand and respond to what detainees were experiencing. He states that he was not alone in thinking this, and he recalls others on his shift saying the same thing. But despite having raised this issue with G4S, my client received no mental health training. Indeed, my client may have believed he was actually doing some good by speaking harshly to detainees. He talked in his statement about trying to snap someone out of an emotional or vulnerable state. Dr. Hard told the inquiry on day 39 that staff didn't understand D1275's mental health problems. He confirmed they weren't concerned about his welfare as such, rather they were frustrated by the presentation of his symptoms, and the nurse in the room behaved no differently. The inquiry witness Professor Bosworth dealt with this issue on day 40. She said that the training given to DCOs was pretty minimal and focused on security. It did not enable staff to see the residents on the to see residents as highly vulnerable, but rather dangerous and difficult. She recommended that mental health training have a focus on secondary trauma training for DCOs, as that would enable them to conduct their duties with empathy and recognise that the dehumanisation, aggression and losing control of emotions that we've seen in the evidence can be symptoms of secondary trauma in the detention centre staff themselves. There appears to have been no mental health element in CNR training. John Collier told the inquiry that the test criteria used to medically evaluate the appropriateness and safety of CNR techniques employed in an IRC does not include consideration of mental illness or vulnerabilities such as history or torture, of torture and trauma. And Chair, this is a matter of some concern, as mentally ill detainees subjected to these procedures in the relevant period are likely to have found the experience terrifying and to have been re-traumatised by it. But none of this was in the thinking of G4S or the Home Office. So we say that the inquiry should recommend that all IRC staff receive mandatory mental health awareness training, including PTSD training, from a recognised and independent source such as HMIP. Chair, the second issue is that Brook House involved a unique situation for which the training given to DCOs was inadequate, and Mr. Francis's evidence highlighted the fact that it was no ordinary detention facility. He stated in his evidence that there were DCOs who left Brook House shortly after completing their training because they realised they hadn't been properly trained to deal with the condition there. And a particular problem, as Mr. Kelly has touched on before I spoke, and as Mr. Lee submitted in his submissions in relation to D643, who was at Brook House for 558 days, is that some individuals believed they would be staying at Brook House for 2 weeks or 2 months, but ended up staying there for 2 years. In reality, Brook House must have seemed like a place of internment for many who were there. Unsurprisingly, this created levels of exasperation and desperation, and many detainees would eventually lash out and resort to self-harm. Professor Bosworth said in her evidence on day 40 that this issue affects staff because it makes their role unclear. She said, if you don't know how long someone is there for, it's hard to motivate yourself to invest in them as a person. She said that this factor affected staff culture and led to desensitization as a mechanism for dealing with people whose staff members were unable to help. Another problem which Mr. Francis highlighted in his evidence was the mixing of often dangerous and violent criminal deportees in cells with vulnerable asylum seekers or overstayers. And we saw this on the Panorama programme, and my client says this led to intimidation and bullying of the non-criminal detainees. There were also high levels of the drug spice that came through the doors, largely unchecked, and my client confirmed in his evidence that he received no training on substance abuse and would dread the prospect of violence, which was potentially likely when the effects of the drug wore off. It's quite clear, Chair, that Mr. Francis's evidence is that Brook House was dysfunctional, with unique systemic problems for which no proper training of staff was given to Mr. Francis and other DCOs. Third issue is that detainees, many of those at Brook House, were simply not suitable to be kept in detention in the first place. And that affected my client's working conditions, and that is an issue that has been exposed by the Panorama programme. No amount of training could have equipped my client to deal with those detainees whose experiences of past torture or whose mental health conditions were such that they were incapable of being managed in detention. Dr. Hard said on day 39 that rules 34 and 35 were not properly operated in the relevant period. We've heard that in only operating a nursing screen on arrival, healthcare failed to take account of the specific needs of the detainees. So DCOs like my client, DCOs like my client were charged with looking after individuals who had already been failed by healthcare. Dr. Hard agreed with the view taken by Medical Justice that the arrangements at Brook House made it impossible to comply with Rules 34 and Rules 35. My client stated in his evidence that the E-wing segregation, that's the wing on which he worked, was used to manage distressed behaviour, including self-harm and suicidal ideation, certainly not for the purpose of providing treatment. And Dr. Hard stated that E-wing detainees were primarily being managed by detention staff with very little clinical input. Sandra Carver gave evidence that some people did indeed deteriorate as a result of being on that wing. So much of the detention in the relevant period in 2017 was unlawful detention. People were being kept in conditions where they hadn't been properly assessed, when, if they had been assessed, they would have been released under the DCO and under the Adults at Risk policy. And I should say a little something about that policy. There is a problematic element to it because it involves a balancing exercise between risk factors and so-called immigration factors, which has been criticised. But there's an underlying presumption that detention will not be appropriate if a person is considered to be at risk through having experienced traumatic events or where there is a medical or professional or observational core evidence that an individual is suffering in the way that they have a condition such as a mental health condition that would be likely to render them particularly vulnerable to harm if they're placed in detention or remain in detention. Yet that system didn't work because it was let down by a culture of disbelief by healthcare at Brook House. So Mr. Francis' position is not only was he inadequately trained to deal with detainees who were lawfully present at Brook House, but he was required through systemic failures to deal whilst untrained with numerous detainees who suffered from mental health conditions which, under the Secretary of State's own policies, rendered them unsuitable for administrative detention. Chair, the fourth issue is that Brook House was understaffed at the time and run for profit by G4S, and this was a contributing factor to the situation in Brook House which affected my client and which is shown in the Panorama documentary, the financial motivation of the institution that was charged with running the facility. And we saw evidence yesterday that the tender delivered 35 cost savings compared to the original budget. Nothing, in my submission, my client was required to work in an inhuman environment where removal and security were prioritised over health and safety. And nothing underscores this point better, the perversity of the situation at Brook House, than the penalty points in Schedule G of the G4 Home Office contract, which fix a fine of £30,000 if a detainee escapes, but only £10,000 if a detainee dies. And that's the underlying perversity of the system as it operated at Brook House. Sarah Newland of G4S gave evidence on day 34 and said that G4S ran Brook House as understaffed during the relevant period in order to attain profit, and that this was evidence of G4S prioritising profit over detainee welfare. It is inescapable that my client was required to work in difficult conditions due to understaffing. He says in his evidence most of the time there weren't enough officers. Usually there would be 2 officers in the place of my work, and 1 officer would have to go down to conduct searches or monitor or appear at a case review. Very often I was the only officer, and that would increase the pressure that I was under. Mr. Francis has also stated in his statement that the work was constantly juggling plates, with detained people having problems and officers having to respond to a crisis with each detained person. I would go home after a 12-hour shift, and we'd come back later 6 hours after that and do the same thing again, which really took it out of all of us. I remember a new staff coming on to where I was working and saying, "How can you possibly do this day in and day out?" Mr. Francis described his work as mentally draining, and he referred to 12-hour shifts with a 1-hour break. And officers on the wing where he worked would have to be there from 7:45 until after 5 o'clock in the afternoon, occasionally without staff cover, to enable them to take a break. Chair, in answer to questions from yourself, my client, when he gave evidence, said it would have been helpful for him to have had other staff present to have taken him away from a situation where he was feeling frustrated or tired. However, G4S didn't provide that staff support to assist when officers were struggling to cope. And that is because, Chair, they had no motivation to do so. The fifth issue is whistleblowing. My client told the inquiry that he was horrified, shocked and mortified at Jan Pashali's actions on the 25th of April 2017. However, he told Mr. Altman that his life would not have been easy had he tried to speak of his concerns. Callum Tully told the inquiry that there was a speak out poster on the wall outside some lavatories. However, it had been defaced with words such as snitch and grass. Effectively, my client was powerless to report the abuses that he'd seen and experienced, and I would draw your attention to what Mr. Stanton has said about his client and the issue in relation to the racist comments that Mr. Syred attempted to report and how he was treated in the aftermath of that. Callum Tully told the inquiry that he had no option other than to go to the BBC because officers would have closed ranks and it would have been their word against his. There was also a further systemic problem in relation to reporting conduct, and you've heard the evidence of Stacey Dean, who made a complaint in 2015, and she says that the senior management team at Brook House was consistently uninterested, and some SMT members found the situation amusing. So Mr. Francis was dragged into a culture which had an absence of effective complaint procedures, and DCOs were in effect powerless to change the system. Chair, the sixth point is that the Home Office created a hostile environment. The ethos of the Home Office is a significant issue in this inquiry. Ben Saunders gave evidence on day 35 and confirmed that the Home Office created a hostile environment, and that was linked to discouraging people from coming to the UK in the first place. He said in his Verita interview that detainees at Brook House, that the Home Office line was that detainees at Brook House had had opportunities to leave the UK, and if they found themselves in an IRC, well, they brought this upon themselves. He went on to confirm that although some individuals in the Home Office may have cared, as a corporate entity, the Home Office was more interested in getting people out of the country. It is this approach which has ultimately led to the dehumanisation of the detainees that we've seen on the Panorama programme. Dr. Patterson has stated that there is a higher risk of dehumanisation when the victim is a member of a marginal group, which would be foreign nationals facing removal. Dr. Patterson referred to the narrative which has gained prominence since 2012 as a result of UK government policy, which has sought to create a hostile environment, the aim being to create a life so unpleasant for an undocumented migrant that they would voluntarily choose to leave as their access to public services becomes increasingly restricted. And on day 40, the professor agreed that this dehumanisation contributes to the risk of abuse. She said that the only moral narrative about IRCs from the Home Office's point of view is either one in relation to security, dangerous criminals, or a moral narrative. They don't deserve to be here. We owe them. This narrative, the Home Office's narrative, led to desensitisation and dehumanisation of staff members. Karen Churcher said it was the Home Office's view that detainees with mental health difficulties were better off in detention rather than being released from detention. And Lee Hanford says that the Home Office criticised G4S staff for showing too much empathy. On day 40, what Professor Bosworth said is that the Home Office must have known what was going on, but her understanding is that they did not concern themselves with detention. And Dr. Hard has agreed that people suffering from PTSD may go on to suffer from secondary psychosis in detention owing to the stresses of being there and traumatisation. Chair, Mr. Francis was required to work within a toxic culture at Brook House, but the entire system was dysfunctional. The Home Office were aware and caused this dysfunctionality. Essentially, the Home Office's view was that they found Brook House too cumbersome to bring about any meaningful change, and as Mr. Altman put to the corporate witness yesterday, they simply sat on the problem. And I endorse what Miss Morris said this morning, that at the best, all the Home Office are doing is tweaking around the edges. So in relation to the findings that we ask you to make, I endorse what Mr. Armstrong has said, that you must make bold and robust findings because we don't want another inquiry to sit here in 5 years' time dealing with the same points. Ultimately, while my client behaved unacceptably towards detainees, he was at the centre of a perfect storm, where DCOs were not trained to deal with mentally ill detainees at a facility in which men were often detained for apparently indefinite periods, in which detention of those with mental health problems was very often unlawful, in which vulnerable asylum seekers and visa overstayers were required to share rooms with dangerous criminals, in which there was a drugs and violence problem, and in which segregation was used as a means of managing vulnerable detainees. Furthermore, the facility was run by an organisation that prioritised profit over safe staffing and the welfare of detainees. And on top of all of this, Brook House was overseen by a government department that has sought to stigmatise and marginalise immigration overstayers, failed asylum seekers and criminal deportees. So we ask on Mr. Francis's behalf that the following recommendations are made. One, that the Home Office exercises a greater degree of oversight of IRCs to ensure that contractors operate in a transparent fashion, so we don't see a repeat of those incidents on the Panorama programme. That contracts with IRC operators are varied or drafted to contain provisions requiring prioritisation of the welfare of detainees. That those contracts are varied or drafted to contain provisions requiring mandatory staffing levels. That all IRC staff receive mandatory mental health awareness and PTSD training from a recognised and independent source, such as HMIP. That all IRC staff are provided with counselling and other facilities to manage secondary trauma and stress levels. That those who are unsuitable for detention, as Dr. Hard recommends, are screened out at an early stage, in which the Home Office engages with independent medical advisors to assess individuals prior to admission to an IRC. That segregation is no longer used as a means of managing those with mental health problems. That effective complaints whistleblowing procedures are implemented in all IRCs with a specific focus on dealing with the abuse of detainees. And that policies are brought into effect to bring about the change to the culture within the Home Office in relation to immigration detainees. And finally, that the practice of apparently indeterminate detention is brought to an end, with detainees being informed of a fixed date when their detention will end in the event that they can't be returned to their countries of origin. I agree with Mr. Armstrong that this does fall within the terms of the reference of this inquiry. Chair, unless I'm aware of the time, I think I've ended at the right time. Unless I can assist further, then those are my submissions.
Thank you very much, Mr. Jacobs. I'm grateful for all of those submissions that I've heard today, and we will be returning tomorrow at 10 a.m. for the remaining submissions. Thank you very much.